Hello and welcome back to the show. Well, did you know that there are thousands of people who are injured on the job right here in Louisiana every year, and very often they are shocked to learn the real truth about how the Louisiana workers' compensation system works. Well, today, to help walk us through it is attorney Mike Whitehead, who has been practicing workers' compensation law for more than 2 decades.
My friend Mike is one of the best minds on this subject, and he has helped me on workers' comp cases in the past. We got a lot to get to, so let's get right to it. Mike, why don't you explain for people what is a work comp claim, what happens to somebody when they get hurt on the job? What are their rights?
Well, in the most basic sense, John, a workers' compensation claims comes from an injury at work, and the injury may or may not produce a disabling condition. You may be hurt but able to work, and you may be hurt and not able to work. And so workers' comp essentially has 2 sides. One is the employer's obligation or responsibility to pay for your medical bills, and if you are disabled and can't work, the employer has a responsibility to pay you for some of your wage loss.
Well, as I mentioned, you've been doing this for more than 2 decades, so you've seen lots of cases. What do you find, though, when it comes to people who are injured? Do they know what to do first?
I would say, as a rule, most people have absolutely no idea. If they know anything, it's from a friend, a family member, an acquaintance who may have had a workers' comp claim themselves. But as a rule, most people are completely at a loss and don't know where to start.
And so what do you say? Where should they start?
You start by going to your employer and letting them know without fail that you have been hurt, and you'd be surprised how many people attempt to keep working when they're hurt and say, well, I don't want to tell my employer about it, I want to keep my job. And that can be a very bad thing later on if you don't report the injury.
Let me add to that, and as I alluded to in the very beginning, I actually do work in the area of workers' compensation law, and many times I've involved Mike Whitehead, who works exclusively in the area of work comp law, representing the injured. And in fact, one of the nice things about Mike here is he previously worked on the defense side, so he has a perspective having represented employers, and now in the years past doing almost exclusively work representing the injured. But perspective, somebody gets hurt on the job. Well, number one, let your employer know then and there on that day. Tell your supervisor, I just fell down. I just slipped and fell down. Something just fell off a shelf and hit me in the head. I'm bleeding. Maybe I need to get to the hospital. Let them know, okay? Number two, if you're conscious, somebody else, you tell them. If it's not you, hopefully they find you and they report it. Right. Get medical care. Obviously, your health is number one, right? Get to the doctor, get treated. If you can return to work, well, good, then you're lucky. If you can't return to work, you have the option, you have the right, of course, to get your medical bills paid by the employer. Not your health care. If you have health insurance, your employer.
And that's a very important distinction to make,
and we'll talk about that too, but your employer owes you for your medical bills that are the result of the injury, and owes you wages if you cannot work as a result of the injury. Not 100% of your wages. Why don't you talk about that?
No, and that's a big misconception. People believe that if you've been injured and can't work, your employer or their insurance company has to pay you 100% of your wages. But as a rule, workers' comp is 2/3 of your wages. So if you're disabled, you're only entitled to 2/3 of your wages, and there's a maximum amount that is owed weekly. So if you were a very, very high wage earner, you're going to be capped at a level that's far below what you actually earn.
Right. Well, so who do these laws apply to? I mean, does it matter if I'm an hourly employee or a full-time employee? Does it matter if I'm hurt?
Well, as far as being owed workers' compensation, it does not. That comes into play on how your wages, it's based on your average weekly wage, and that is simply goes to how your wages would be determined. In other words, how much your employer would owe you may be determined differently if you were paid on production or paid hourly or paid by the day or by the year. So
let me put that into practical terms. Let's say you made $300 a week. That's what you made, $300 a week. Easy math, 2/3 of $300 a week is $200. If you cannot work for a whole week, you're owed $200. If you can't work for 10 weeks, you'd make at $300 a week, $3,000, you should be paid $2,000. and then your doctor says you're able to return to work, and you agree you're able to return to work. That's generally speaking. Now, sometimes the employer disagrees, and the employer wants you to see a doctor that the employer or the employer's insurance company says, and the employer's insurance doctor says, I think you can return to work, but your own treating doctor, and you can choose your own doctor, your doctor says, no, this person cannot return to work. He's still got bad back problems on down the road. That's one reason why you use the doctor. Did I get that right? You agree with that?
Right, John, absolutely. An injured worker has a right to choose their own doctor in a reasonable field. If you have a back injury, your employer is not going to be obligated to pay for a cardiologist, but they certainly would be obligated to pay for an orthopedic doctor or possibly a neurologist or something of that nature. But by the same token, the employer can require the employee, quote, from time to time to see their doctor. It's a tit-for-tat system, so you can choose your own doctor, but that employer has a right to have you examined by their doctor as well.
Well, both of you know very well how contentious these sorts of cases can become, and oftentimes, and I don't know, maybe in every case, it's important for the employee to have legal representation. You know, what is it going to cost me if I want to consult with an attorney, if I need to hire an attorney? We're talking about, you know, a major expense here?
That's really good. That's a really good question and really good news. Mike, why don't you?
Well, the good news is I'm unaware of any attorney that will charge somebody to come in and sit down and talk about a workers' comp case. If you have a question of whether you have a comp case, my advice would be to certainly call someone. It's an ounce of prevention, as they say. And those attorneys are not going to charge you to sit down and talk initially with you about your case.
And in addition, if you need to, let's say you find a workers' comp attorney, and you sit with that attorney, and the attorney says, I think you have a work comp case, and I think it's, and my advice is, since the employer is apparently not taking good care of your due medical benefits, your medical bills need to be paid, looks like you're not getting all the wage benefits you should be paid. That means you're not getting paid the money you should be paid to live on while you're not able to work. Probably a good idea to hire a lawyer. Me, or maybe another lawyer if you want to go consult with some other lawyers. You don't have to take money out of your pocket to pay that lawyer. So that's something you really need to know. You don't have to sign on the dotted line. You're not going to owe money to that lawyer under our laws. You only have to pay that lawyer when that lawyer is successful in making the employer pay benefits. And the wages are capped by statute, typically at 20%. And if the lawyer can show that the employer treated you badly, was not acting properly and paying benefits, the lawyer might be able to make the employer pay penalties and pay attorney fees. So
there's so much to get to, and we are quickly running out of time. But before we get to our next segment, let's talk a little bit about undocumented workers and how the laws apply to those undocumented workers. Who wants to take us out?
Good news. Why don't you tell them, Mike?
That's been not only here in Louisiana but across the country. That has been an area that has been litigated and gone to court many times, and has been fought very, very hard by employers. What the courts in Louisiana have said is, we're not concerned with whether or not an employee is here legally or a documented worker. The right for that employee to recover benefits comes from the fact that there's an employment relationship. Just the fact that the employer has hired the employee gives that employee rights, if they're injured, to recover workers' comp benefits. So
there's no reason to fear there on the side of the employee. If you're injured, and you should report that.
John,
just talk to a lawyer. They have rights. The law gives people rights, but talk to a lawyer. That's the short answer.
And it's important to note that the laws are different state to state. Is that right? The workers' comp laws are different?
Workers' comp laws are different state to state.
Okay, all right. Well, we have to take a quick break. Coming up next, your questions for Attorney Whitehead when we come back. So stay tuned. We'll be back in just a few short moments. Welcome back, everyone. It is time to get you in on the conversation, and our first question comes from Beverly. She says, I've often been asked by friends and family if they worked for cash and did not receive a 1099 form and they actually got hurt at work, do they qualify for workers' comp, or does work for cash disqualify them from benefits?
The short answer is they're absolutely entitled to workers' comp benefits. They may have a little more trouble proving what they actually earned, but the short answer is working for cash, you're still absolutely qualified for benefits.
You are absolutely qualified. Okay, yes.
That's an easy answer, though. That's you just, sometimes the employers say, I don't know that person, and she never worked for me.
Right.
So hopefully you have coworkers, other people you can say, oh yeah, she showed up for work every day and she helped paint the walls or whatever.
Whatever. So. Okay. So let's get to some of these other questions. So much information. What if your employer wants you to use your own health insurance instead of filing a claim through workers' comp, which that's an issue that comes up a lot for employees? How should they handle that?
Well, the short answer to that one is also don't do it. If you were hurt on the job, you need to report to whichever medical provider that you see. I was hurt on the job. And employees receive a great deal of pressure from employers. Oh, please don't report this accident. My premiums will go up. But what will happen is if the employee follows that employer's advice or request, later on down the line, John, as you know, it creates huge problems for that employee.
Yeah, you never want to be that person who is accused of being dishonest, because your word means everything. You don't want to have your credibility ever attacked. And if you are somebody who, for the benefit of getting a pat on the back from your employer, later on that same employer will throw you under the bus and say, you're dishonest about how the accident happened, you're dishonest about whether or not your back's really hurting. You know, tell the employer, listen, I'm grateful to you for the job, I'm grateful to you for whatever, but please don't ask me to be dishonest. If somebody asks me, you know, how the accident happened or whether or not this happened on the job, I got to tell the truth. I can get in trouble. You can get in trouble, so don't put yourself in that situation.
That's very important information, because it might be difficult for an employee to say that to an employer. You know, you don't want to do anything to jeopardize your job, right?
Exactly. And what you'll find so many times is that employee will trust the employer, and rightfully so. They may have had a very loyal relationship. But later on, the workers' comp insurance company comes into play, and many times the employer may lose control, and the insurance company will drive that claim and make the decisions.
And let me tell you, you employers out there, you don't want to risk yourself getting in trouble. That work comp insurance is your own safety net. Don't take that chance. You can get in criminal trouble potentially, but also risk losing your work comp coverage on other employees. It's just a tangled web. You don't want to go down that road. Well,
this brings up another issue. What if the employer doesn't have workers' comp insurance? What happens in that case?
Number one, get it before you have an accident on the job. Number two, tell them about the penalties.
Many times it's a lose-lose situation. The employer puts themselves in a position of paying penalties, extra workers' compensation benefits. For the employee, so many times, if that employer doesn't have workers' comp insurance coverage, then they may not have the assets to pay the claim, and the employee may do without. So it is a bad situation for both parties, potentially. The employer, even if they don't have insurance, still has a legal obligation, a duty to pay that injured worker medical benefits and wage benefits. So it doesn't get them off the hook.
It doesn't get them off the hook, and I guess that's something that you really wouldn't even know until you find yourself in that situation. Let's take another question from Alan. Alan writes in, he says, after I got hurt on the job, I had an ugly scar and numbness on my jaw. Does workers' comp compensate me for that?
That's a very good question, and Louisiana does have what's called a scarring statute, and it's principally thought of when you lose possibly a digit or an arm or a leg, things of that nature. But it's been translated that if you receive scar, it's any type of scar, a judge gets to decide in what that scar is worth in a number of workers' comp weeks. Yeah. So it does have a value in terms of the scar, and typically what we've seen is, and as you can imagine, a scar for a woman is worth a lot more than a scar for a man. The numbness, you're just stuck with the numbness. You don't get compensated for that.
Wait, okay, so you said the judge will decide what the scar is worth. Say that again?
That's correct. They assign a value in number of weeks. So if you have a really bad burn on
that's in addition to your lost time on the job.
That's exactly right. That's over and above the weekly benefits that you would owe if you're not able to work. So a judge may look at a very bad burn on a woman's arm and said, you know, that's worth 100 weeks, or that's worth 50 weeks, and so it's a very arbitrary.
A whole year's wages at 2/3 your wages,
right?
Or 2 years. And Mike also alluded to something else, and let me add to that. You might have a bad accident where you lose a digit, a finger, two. You might lose toes on your foot. You might lose, have your arm amputated, a leg amputated. That has a certain value, which under the law you're only compensated in money, and under the workers' compensation laws, that translates into how many weeks of pay, as up to what, 10 years?
Up to the scarring claim, I believe, is 100 weeks is the maximum.
Only 100 weeks for scarring, but if you lose a leg or an arm,
then it's graduated. An arm maybe 100 weeks, a leg maybe 200. I don't recall exactly, but it's all graduated into.
So, in other words, disfigurement, scarring, being paralyzed, it all has value. But that's why you have a lawyer.
Well, now, what if there's a situation where an employee is injured on the job, but let's say that employee has alcohol in his or her system or drugs in his or her system? That could present a whole other set of challenges, correct?
Quite the challenge.
Oh, that's a great question. And again, that's an area where there's been just so much litigation and so many court cases. And the answer to that question is it really depends. It depends on how much drugs or alcohol that you have in your system at the time of the accident. And it also depends whether or not your employer has a written drug policy. So you have different rights depending on whether your employer has a written strong drug policy, and if they don't. And this is an area that absolutely you would be very hard to get through a comp claim without some legal guidance. So if anyone has that situation, I would strongly advise them to immediately contact an attorney.
Let me put that into an example. You are on the job, you slip and you fall down and you have a bad injury which stops you from being able to work. You're disabled for a while. They take you to the hospital, they do all kinds of tests, you have a bad injury, but the urine test or the blood test shows that you have marijuana in your system. Well, the employer is going to say, we owe you nothing. We don't even have to pay your medical bills, we don't have to pay for your medical treatment, and we don't have to pay you wages while you are disabled from your injury because you had marijuana in your system. And understandably, the employer is, in some cases, justifiably is going to say, you were high on drugs or alcohol, whatever, and that caused you to have the accident. Well, if the drugs indeed were the reason why you had the accident, well, that's understandable. On the other hand, if you had drugs in your system and somebody else driving a forklift is not paying attention and they run over your foot, well, you want to say, well, number one, you don't have a drug policy. You don't have a written drug policy. You didn't inform me of the drug policy. And most important, the drugs in my system had nothing to do with me being injured. It's simply outrageous that you would use that as an excuse not to be accountable to me, and now my family goes starving while I can't work. So that's why an attorney should be involved.
Well, it seems like it would be cut and dry, but really it's not.
No, it's not cut and dried, and what you can count on every time, if there is any type of positive drug test or alcohol test, whether or not that's enough for the employer to really deny the claim, they are going to deny it each and every time. And so most times an employee has to fight that in order to get benefits.
So is it a situation where every time someone is injured on the job, it's a legitimate claim, or at least they should file a claim, and then the legitimacy of it will be determined at a later time? But if you are injured on your job, should you automatically file a workers' comp claim?
Well, the short answer to that is, if you're injured and you can't work, you're certainly entitled to benefits. And you're certainly entitled to have your medical bills paid. And if your employer's not doing that, you may have to resort to that. Now, some employers are very cooperative and they will voluntarily pay benefits. But even if they do, that doesn't necessarily mean that you should handle the claim by yourself.
Okay. All right. Theo writes in and he says, if I have a second job and get hurt on the other job, will my first job pay for lost wages for the other job? So someone here who's working multiple jobs wants to know, if they get injured on one job, does the first job have to pay the lost wages for the other job? Sounds a little bit confusing there.
Well, it's a very good question, but that also has a short answer. If you're hurt on the job and you have another job, your insurance company is only going to pay for the job upon which you were hurt.
Okay. Okay.
And that's the short answer.
That's the short answer, and I'm glad that you made it a short answer because we are completely out of time. Thank you so very much for being here. We've learned a lot and lots more to learn, so thanks so much for coming on the show.
Thank you both for having me.
Thank you, Mike.
That is it for our show this week. We hope to see you back here same time next Tuesday as we delve into yet another important area of the law that could affect you and your legal rights.
Remember to look us up on Facebook, follow us on Twitter, and visit the show's website, jrpoa.com or johnredmondpoa.com, to watch past episodes and get useful info on everything discussed on the show. Thanks for joining us, and we'll see you next week on LAU.